This afternoon on the Legal Hour, we tackle a topic that many people never expect to face, yet one that affects thousands of South African families every year, and that is divorce. Now, ending a marriage is not only an emotional journey, but also a legal and financial one. And from understanding the divorce process to deciding on maintenance, the division of assets, pension interest, and also a responsibility for debt, knowing your rights can make a significant difference during this very difficult time. And joining us to assist us with this is Advocate Abduroaf, Advocate of the High Court of South Africa, and family law expert who will guide us through the legal processes and also helping us to understand the financial implications of divorce. Advocate, Assalamu alaikum and shukran so much for being here once again.
Wa alaikum salam and shukran for having me once again.
Always a pleasure speaking to you. Now, let's begin with what are the legal grounds for obtaining a divorce in South Africa, and what is the first step someone should take if they are considering divorce?
From a starting point of view, divorces, we refer to that a court of law will grant you. Therefore, in South Africa, there are only three types of marriages. One would be in terms of the Marriage Act, another will be same-sex, and another one will be customary marriages. But divorces becomes a bit interesting because in terms of the Divorce Act, it also allows a divorce in terms of a Muslim marriage. So there are four types of divorces, but three types of marriages that are recognized validly in South African law. But moving on, the bottom line is the marriage should have been broken down irretrievably. Basically means that the marriage cannot be saved. Even if the parties try counseling, they see the Maulana, they see the priest, they see these professional people, the marriage cannot be saved. Both parties do not want to remain married with each other. Or maybe one party wants to remain married, but the other party mentally and emotionally decided I moved on or have moved on, and the marriage cannot be saved. So the bottom line is the marriage cannot be saved.
Now, if you have just joined us, it's Radio 786 and 100.4 FM. And of course, we are in conversation with Advocate Abduroaf, an advocate of the High Court of South Africa and family law expert, guiding us through the legal processes and helping us understand the financial implications of divorce this afternoon on the FI show's Legal Hour. Now, what is the difference between an uncontested divorce and contested divorce, and how does this affect the cost and the length of the process?
The ideal is to have a uncontested divorce. That is a divorce where the parties agrees that the marriage has broken down and they agree upon the consequences of the divorce. For argument's sake, they agree what happens with the property, they agree what happens with the kids and maintenance and so on. That is an uncontested divorce where the party says they agree that the marriage has broken down, we agree upon the following, and one of the parties proceeds to court uncontested, unchallenged, and the divorce will be finalized in a few months or very soon. So that is uncontested. Very cost effective because it's unchallenged. Then we're dealing with a contested divorce or a defended divorce or an opposed divorce, where basically the parties are fighting. They're either fighting based on what either one of them believe is best for the kids. So the mother might say, I want to have custody over the kids. The father says, no, I want to have custody, or I want to have more contact. Or they fight over the money aspect, the division of the joint estate, or maintenance for each other. That can be extremely expensive. And to put it in a nutshell, an uncontested divorce, and let's say go to an attorney, could cost maybe between 5, 10, 15,000, and depending upon the nature of the things that must be dealt with, property and so on. But when you're dealing with contested divorce, we're talking about anything above, and best case scenario would be 80 to any amount above that, $250,000, $1 million, and so on, depending upon what we're dealing here with.
Now, many people are unsure whether they need a lawyer when going through this process, right? But is it possible to get it divorced without legal representation? And also, when would you strongly recommend seeking legal representation or assistance?
So in South Africa, you do not require to have a lawyer for any legal matter. But I would not advise you to do a divorce on your own if there are potential challenges that might arise. For argument's sake, let's say there's a pension fund. Now, if the divorce order does not properly deal with the pension fund, then you'll have to come back to court later on and ask the court now to change it. The court is not your lawyer. So if you approach your court and say you would like to get divorced and you would like the court now to make an order that his pension, half of it, gets paid over to you. If those clauses are not properly drafted, like for example, many people will use a word incorrect like pension, interest or whatever the case may be, those specific clauses need to be properly inserted into the divorce order. And the court won't do that job for you. Another example would be the debts of the joint estate. Are we now dealing properly with the debts of the joint estate? If the parties are married in common of property, that's very important. And obviously aspects regarding businesses, policies, children as well. The clauses need to be properly drafted. Because you do not want to have a situation where the court just says they grant you a decree of divorce, and for argument's sake, they say custody gets granted to the mother. A month later, what happens to the house? What happens to the car? What happens to our debt? What happens to our pension funds? Those are important things that should have been dealt with in the divorce process. What happens to the kids as well? So if it's a simple thing where the parties have no kids, there's no property, there's nothing, and they were married for a very short period of time, and all that you require is a decree of divorce, then maybe yes, do it on your own. But if it becomes a bit complicated, don't try to save a few thousand rands with a problem that is bound to happen later on.
Okay, now one of the biggest concerns is, of course, maintenance, and we've said this many times. But how exactly is spousal maintenance determined, and is it always awarded after a divorce?
A court would very rarely grant a decree of divorce unless the issue of maintenance is resolved. That's very important to note. There are circumstances where the court might grant a decree of divorce and saying, okay, I'm granting a certain maintenance order in the interim, but the party has a right to approach a maintenance court afterwards. Or the court might make a determination and saying that the other party cannot afford maintenance and there will not be a maintenance order, but the right to go to the maintenance court is always there. But maintenance seems to be the deciding factor in determining whether or not a divorce will be contested or not. Because while the parties are married and they're living in the same household, it's very easy to determine, or we go historically, you paid for this and I paid for this. But how do you determine going forward, now that there are two households, what the maintenance obligation should be? Because now there'll be two rentals, there'll be two cars that must be driving the kids around, two petrol bills, for example, and so on, two electricity bills, water bills, and all those things. So we have to now work out with a professional person, determine what is the reasonable expenses that a child would incur after the divorce. So you have to work out, example, what will rental be? What will this cost? What will that cost? Who will pay for the school fees? Who will pay for this? Who will pay for school, for food? So that's why I'm advising it's easier to go to the divorce court and get a divorce very quickly. Yes, you will be divorced very quickly because it's uncontested. But have you resolved these issues? Or you're basically saying, get divorced now, but later on we'll fight the maintenance in the maintenance court. Later on we might come back to court to sort out the pension fund. Later on we might come back to court to sort out the debt.
But now, like, my concern is always the children, because there's always children involved. And so when children are involved, how exactly does the court determine child maintenance and ensure that the best interest of the child is priority?
So the court will only have to make the determination in a contested divorce because the parties cannot resolve upon that. So the court will have to make a determination what are the reasonable needs of these kids. Very important, because, I mean, logically speaking, if mom and dad, I'm using round figures here, for example, earned 5,000 each, it's impossible for the child's expenses to be 15,000 rand. It cannot work. It doesn't make logical sense. So the court will have to determine what are the reasonable needs of the child: school fees, general accommodation, clothing, and so on. The court will have to make that determination. And then the court will now have to determine what can the parents afford towards that specific expenditure.
Okay.
For argument's sake, let's say the father earns, in this example, 10,000 rand, and the mother earns 5,000 rand, and the child costs technically 1,000. That means the father will have to pay 2/3 and the mother will have to pay 1/3. So the father will basically, and if the kids goes to the mom or the child goes to the mom, the court will make an order that the father should pay 663 rand or so, a third, 2/3 of the child's expenditure. So that's how the court will basically deal with it.
This is Radio 786 100.4 FM, and that the voice of Advocate Mohammed Abduroaf, who joins me in studio, and we are discussing something that many of us may never think about when we get married, and it happens very often, and that's of course divorce. And we mentioned earlier that ending a marriage is not only an emotional journey, but it's also a legal and financial one. And so we are really looking at ways and means and certain ways how advocates can guide us through those legal processes, and also helping us understand the financial implications of a divorce. Now, when we look at assets divided during the divorce, how does the marital property regime, whether in community of property, out of community of property, or with accrual, affect the outcome of something like this?
My view is that there shouldn't be an argument regarding the division of the
Assets.
It shouldn't be, because if you're married in community of property, either you guys come to an agreement, or the assets must be sold and the proceeds must be divided equally. Simple as that. In today's times, it's very rare that you find people who do not have outstanding amounts on the bonds. You do find, but of course, it's not the general. And if the parties cannot agree that the one party should purchase the property or obtain the property, then that property must be sold. The bond must be settled, and must share the proceeds of that property. That is, if they are married in community of property. And also the debt is very important, because if one spouse married in community of property incurred certain debt, whatever it is, like an account, purchase a car, whatever the case may be, that debt forms part of the joint estate. Therefore, at divorce, that specific debt has to be factored in the division or in the resolution of the division of the joint estate. So that's very important to note. If the parties are married out of community property without the accrual system, where the understanding is that what belongs to you belongs to you, what belongs to me belongs to me, debt, assets, whatever it is, that should be very simple. If the accrual regime applies, obviously the accrual regime means that any wealth you accumulated or the growth of your estate during the marriage must be shared between the spouses, of course considering inflation and so on. So for argument's sake, let's say at the start of the marriage, the husband's estate was worth 10,000 and the wife's estate was 0. During the marriage or at divorce, the wife's estate is now worth 20,000 and the husband's estate is still worth 10,000. Her estate grew by 20,000. So she must pay the husband 10,000 rand. That's how the accrual system works. And he has to pay nothing to her because his estate hasn't grown. I'm just using the difficult example here, which is not usually the case. Obviously, CPI kicks in as well, the inflation as well. So we have to work out the value of 10,000 rand at the start of the marriage and what the value of 10,000 rand is today. But in that example, his 10,000 rand then would be different than what 10,000 rand is today. But where I'm going to with this is that there shouldn't be much of a debate and an argument. That is how you agree to get married, and that is how the marriage should be dissolved.
Now, one of the other largest assets that often is the case is pension funds.
Yes.
And it is often one of the couple's largest assets. Can a spouse claim a portion of the other's pension, and how does the pension interest work during divorce proceedings?
So if you are married in community property, you are entitled to at least half the pension interest of the other spouse, calculated at the date of divorce. So whatever the value is, what will usually happen is the person who owns the pension fund will contact the administrator and ask, please give me a quotation as to what the value of my pension fund is at this present moment. Let's say for argument's sake, he says it's worth 100,000 rand. So there's two ways here. Either we can offset it on something else. Let's say there is a house and the equity where the person who owns a pension fund must get 100,000 from that house. They can have an agreement. You keep your pension and you can keep the house. So I'm giving you my 100,000 from both sides. So that's how the parties can come to some type of an agreement. But the pension fund does form part of the estate of the parties. So that's very important to note.
Debts. I think debts is another concern. But what happens to debts such as home loans, vehicle finance, credit cards, or any professional loans, especially in community of property?
The challenges people have regarding home loans is that the home loan would be in the name of both spouses. And after the divorce, for one party now to say, I'm keeping the house by agreement, the question still is, does that party qualify for a bond on his or her own name? Because for argument's sake, the bond was granted because wife earned 10,000 and the husband earned 10,000 rand, and that's why they got the bond of the house. Now they're divorced. It does automatically mean that the bank will now say, I'm taking wife off from the bond. The house will go to the husband, but can he afford to pay the bond based upon his 10,000 rand, which he earned initially? So those are the challenges that we have. That takes me back to your question early on. Is it advisable to do a divorce on your own? Because these are the complications that must be resolved before you decide to get divorced. Because in that specific example, if the court just says, we're dividing the joint estate in half, full stop, what happens to this house? The house will have to be sold, but what if one party decides not to partake in the sale of the house? Therefore, the divorce order has to deal with all of these eventualities. For argument's sake, if they don't want to partake, the sheriff is authorized to sign documentation on their behalf.
But now, someone may think that does divorce automatically divide these debts between the spouses?
So the court order will say the joint estate is divided in half, but we don't know what half is half. What happens to the TV? What happens to the fridge? So while the parties are married in common property, that fridge, you don't own the top part or the bottom part or the left or the right. You both own that in an undivided half share of that fridge. So the law expects the couple to figure out a way of cutting this whole estate in half. But if they cannot come to that agreement, usually what they call it a receiver or liquidator, the court will appoint a third party to basically appraise the estate, the joint estate, sell assets and divide the proceeds of it.
Now, advocate, what happens in a case where the one spouse has been financially irresponsible or has hidden assets? What legal remedies are available to ensure fair settlement?
Now, if you cannot identify those hidden assets, then automatically those assets are not in existence, because he will say, I don't have those hidden assets. Under those circumstances, I would advise a client, depending upon the extent of the hidden assets. If it's like, I don't be funny, if let's say it's 10,000 or less, I would say just move on with your life. Because you just spend a lot of money trying to find that assets. But if it's significant assets like offshore assets and assets, properties and assets that's maybe hidden away somewhere, employ a professional person, employ an investigator, employ somebody that knows how to find these specific assets. But sometimes it's quite easy to find them. For argument's sake, you obtain the bank statements of that specific party over the last 5 years or so, and you can connect the transactions that took place in the bank statements. Or various other ways of doing it as well. You can do a credit check on this person. Oh, this person applied for credit here. Why would he apply for credit? Of course, to purchase an asset. Whatever the case may be. But you need to determine what these assets are, so when the divorce gets finalized, it's known to you. Because once the court makes a decree of divorce and you're no longer married to this person and that assets are out of the equation, it's very difficult to deal with them without reopening the whole divorce process, and that can be very complicated.
Now, just something that I maybe should have asked earlier, but when it comes to the contested and uncontested, right, do both spouses need to agree to divorce? Because I've experienced many people, the one feels that they should go for the divorce and the other one doesn't.
For the uncontested divorce, both parties must agree. There will not be an uncontested divorce. It can be a scenario where the one party just does nothing. That is still an uncontested divorce, where, for argument's sake, the husband, he prepares a divorce summons, he has served upon his wife, and in that divorce summons, he asks for A, B, C, and D, and the wife just does nothing. 10 days pass, he goes to court, he says, here's proof that my wife received the summons, she didn't do anything. The court checks the court file, yes, nothing has been filed in the court file by the wife. We can now proceed with the divorce based upon your summons. But that it can become problematic, because what if there are problems later on? What if the husband, in his divorce summons, says, I want custody over the kids, I want this, I want to retain ownership of my house, retain ownership of my pension fund, pay you zero maintenance. And now because it is uncontested, he might get a divorce order. Then later on, when the wife wakes up and she decides, oh my gosh, I was very emotional at that time, I just wanted to move on with my life, but now he's the one with all the money, all the property and all the assets. I have nothing. Now she wakes up.
Yeah. But also, what happens if one spouse earned most of the income during the marriage?
So if one spouse earns most of the income, that income belongs to the joint estate. if they marry in community of property.
And if they're not?
Then it belongs to that other spouse. It's his or her income, but he has a legal obligation to maintain his spouse during the marriage. That's very important to note. So it might belong to him because they marry other community of property, but you have a right to claim maintenance from that spouse during the marriage as well if he is not maintaining you or she is not maintaining you with that higher income.
But now, what happens if it comes to the point of divorce, right? And you maintain the wife during the marriage, obviously, which means that you bought X, Y, and Z for her. And now when you, upon a divorce, you decide that you don't want to give her any of the things that you gave her during the marriage. What happens?
The wife has an option of claiming maintenance from her husband after the divorce. They call it alimony. It's a different term to use, personal maintenance. Then she will have to file a plea and a counterclaim. And a counterclaim will be because of the duration of the marriage, because of the reasons for the breakdown, because of him maintaining her during the marriage and her incapacity to earn money after the marriage, after the divorce. She is now entitled to maintenance from him. He has a legal obligation to maintain her, but she needs to deal with that in her counterclaim in the divorce summons.
Okay.
She cannot just do nothing, get the divorce done, and come back a year or two later and say, oops, now I want maintenance from him. It's too late.
Radio 786 100.4 FM. We are talking to Advocate Mohammed Abduroaf, and of course we are looking at what happens in a divorce process and some of the things that we often find people do. But if we were to look, Advocate, at the common mistakes that people do during this process, what would they be?
A lot of these common mistakes are that the parties don't deal with important aspects in a divorce settlement. Like the pension fund is very, very important. I've seen applications to court quite regularly. We sometimes lawyers are also appointed in the matter. Because you cannot say, I hereby give 50% pension from a pension fund to the other party. That clause is not enough. There are certain ways you have to draft these. Because there's also the Pension Fund Act and all those acts that says we can only allow or we can only pay over money to the other party based upon certain requirements. And those requirements has to be placed into the divorce order itself. So that's something very important. Other scenarios would be, for example, regarding the house, clauses regarding the property as well. Because when the court now says, I hereby grant a decree of divorce, what happens to the bond? Because on the bank side, both parties are still responsible for the bond. But here the husband is still living in the house and she is responsible. So these are important issues to be resolved, because if the bond is not paid, the bank will still go against both of them. So the reason why, despite the parties maybe in a settlement agreement stipulating that we're both responsible for our own debt, which happened during the marriage, from a third party's point of view, the bank or the creditor, they can still go against either the husband and the wife after the divorce. So that's very important to resolve these matters as soon as possible.
And then I just want to go back to one of the previous questions regarding debt. If debt was accumulated together during the marriage, and upon divorce, one party perhaps feels that you divorced me, so I am no longer I don't have any part of the debt, of paying the debt back.
So if that is a scenario, and one party, he pays the debt because the banks are knocking on his door, he or she can proceed and claim that debt from the other side. So for argument's sake, let's say they have a huge electricity bill of 10,000 Rand. Now the wife says, no, I'm not going to pay that electricity bill because I wasn't part of that whole process. The husband pays electricity bill, but he can still sue the wife for half that amount of money.
Okay. We are talking to Advocate about divorce proceedings and really settlements and really what all of that means and how to go about this. But I think that many people somehow delay divorce, and that simply because of the fear of the financial consequences. What practical financial planning advice would you give to someone preparing for divorce?
Now, it depends on how the parties are married. If they are married out of community property without accrual, then that's fine. Life goes on. There is a scenario or the situation that applies, they call it redistribution of assets. So despite you being married out of community property without accrual, you can still claim from the other side an amount of money or percentage of his or his estate if you help that person becoming that person. For argument's sake, let's say we have a scenario where the husband is the one that's running the the show. He's making money and he's doing very well. But the wife is the one in the background taking his kids to school. She's the one that's ironing his shirts and making sure that the household is going well so that he can further his career. When he's studying at night, she makes sure that the house is quiet and clean, and whatever the case may be. But she assisted him to a certain extent, and he would not have been where he is today unless it was because of wife's effort. There's obviously a proportional value to that. Now, despite the parties being married out of communal property and without the accrual system, she can convince the court, and the court can make an order that some portion of his estate must go to her.
Okay.
So that's possible. In communal property, it will be 50-50, and that is the final thing. Regarding the scenario of if the parties were married to the accrual regime, she will now get, obviously, half the difference between the different accruals. So that is fine, and that goes very well over there. So I advise people, make sure that before you get married, understand your matrimonial property regime. If this is exactly what you want, if you see yourself as being a housewife and always being at home, then maybe focus on being married in communal property or at least with a accrual regime. Don't go and get married out of communal property. But if you see yourself as being a business person and going out there and incurring debt and doing risky business deals because that's the nature of your job, then I would strongly advise you to get married out of communal property, but maybe with a accrual regime should something happen in the future. But when it comes to divorce, it's very important for you to get the best possible financial deal out of the situation. And to be fair, that's why I advise people, if you are married out of communal property, seek the advice of an attorney or an advocate to assist you determining whether or not you have a claim from the other party's estate. And to be honest with you, it's very easy for a party to manipulate the other party. It's very simple. The wife, for argument's sake, she could have been hiding money away every month under the sofa, and the husband never even knew about that. He never knew about it. And it might become very relevant later on because that money forms part of the joint estate. So speak to a lawyer, speak to an attorney on these important aspects.
Perhaps just if you could maybe sketch a scenario or two of the common cases that you often sit with as far as the divorce proceedings are concerned.
Yeah, what's happening a lot recently, and I'll be frank with you, is the implementation of the redistribution of assets for Muslim couples. I've seen it a lot. I've been dealing a lot with that since the Constitutional Court said, since the judgment that came recently out where it says now that Muslim marriages, you can now claim redistribution. So for argument's sake, if the parties are married in terms of Muslim rights, and the wife feels that she has assisted the husband with where he is today, she can now claim part of his estate. The funny thing is, I never ever saw a matter like this being finalized to trial stages because it's quite new. So I'm still waiting to see how a court of law, how a judge will actually deal with this scenario. Maybe they give a 5%, 10%, but the claim is usually 50%. And whether another court will grant it or not, I'm yet to see that. But that is something that's happening quite often now within our communities. I would advise, and I do advise all my clients, if they come to my office regarding that, is this claim you're making Sharia compliant? So you must speak to your imam before the time. Because I wouldn't want to assist you where you are now claiming something that is not allowed in terms of Sharia law. And with that as well, it would be that you can have a scenario currently in South Africa where a woman is Islamically divorced from a man, but she can still go to the courts, to the divorce court in the High Court, for argument's sake, and still claim maintenance from him despite him having no legal obligation to nafaka her. So these are the challenges we are now facing now within our communities. So please seek Sharia advice before you endeavor in that specific regard. But from a legal perspective, that is happening now quite often. And it's also happening quite often with clients, and I'm using an example, non-Muslim clients coming to my office now where they're also claiming redistribution. So it seems to me that that entire pack of people that were married out of community of property many years ago, and since that change came in, are now proceeding for the divorce based upon the redistribution, where the wife is saying, I'm not happy with 0, I want part of his estate, or might say, I want part of her estate. It seems to be the new thing that's happening now.
But now, let's be very honest. Most of us are married out of community of property, right? And just by Islamic right. And so when it comes to divorce, we go to the imam and then the talaq happens. But we some may know and some may not know about the new law that is now in place. What advice would you give to people who are still going to be getting married? What advice would you give to them in terms of how to draw up their contract when they do get married to avoid certain things?
My advice to someone is don't. Let me just take my one step back over here. It's with the Constitutional Court's decision. It doesn't mean that because it's available, you can go for it and you'll be successful. I think that's very important for people to note about that. It would have been a smarter move, as you asked me now, that at the start of the marriage, you should know how you're getting married. I'm getting married to this person out of community of property, meaning that what belongs to me belongs to me, what belongs to him belongs to him. And should you or him should they get divorced, the consequences are that I will walk away with whatever I have and he will walk away with whatever he is. Now you need to live your life accordingly to on that specific basis. That's very important to do. Don't live your life in the sky and saying that nothing ever will happen to us and so on. So understand your matrimonial property regime, understand the consequences thereof. But if at default, if you do not understand anything, then get married in community of property. Because then whatever belongs to him belongs to me, whatever belongs to him, me belongs to him as well. But it's something that the party should understand, because nobody goes into an employment scenario without understanding the medical, either getting medical or understanding the pension, they're getting pension. They go into it understanding it and fully comprehending that, and also comprehending the tax implications of it. So if I earn more money, if I get disallowed, whatever the circumstances are, I know the show deals quite in depth regarding that. So exactly the same with a marriage. Understand the consequences of your marriage. Speak to a lawyer before the time and make it to do a proper job.
Absolutely. Now, for those who may be facing the end of a marriage, right? What important legal advice and words of encouragement would you leave with them?
So each client is obviously different, because for one client, money isn't a problem. It's having the child is the issue. She or he wants to have contact or communication with that child after the divorce. Where another couple, things are easy. The kids are 17, 19 or quite old. The main concern here is money. I need to leave this marriage with as much money as possible. Or the wife might say, I want to get as much maintenance from him or her as possible. My advice is, for anything, this is legal, this is the most important decision you make. Because if you, for argument's sake, entitled to maintenance of 10,000 Rand, but you settle for 5,000 Rand, you're basically losing out 5,000 Rand per month for so many years. Not only for yourself, but for the kids as well. It's important to note that you as a mother, when you're applying for maintenance in a divorce, should not be left with zero every month. Many women, they go into a scenario where they say, I want maintenance because I earn 5,000 Rand per month, for example. The children cost 4,000 Rand per month. Therefore, I put my 5,000 Rand into that kitty. The father must only pay 1,000 Rand. I'm using an extreme example. That isn't right. You should see yourself as someone who requires money to maintain yourself, to enjoy your life, also contributing a small amount of money towards your kids, and the father must also do the same. But more importantly, maybe on the other aspects as well. I've seen it so many times when a client will come to my office and say, advocate, they hit me or hit the table and say, advocate, I want to get divorced. And that's all they want to get. They don't care about the property aspects, whatever the financial issues are. I let the clients say what they want to say, but I know the back of my brain that if I am to resolve your divorce with you in the next 2, 3, 4 months' time, you will be divorced. But then I will see more of you after that later on, because then there are unresolved issues. Because you just signed away for a minimal amount of maintenance, or you signed away your kids, or you signed away the pension, you signed away the house. Therefore, make a very informed decision. And what you know about our discussions are the issue of emotions. Take emotions out of the picture. It's very, very important, because whatever decision you make regarding a divorce, it will affect you literally for the rest of your life. Because if you only ask for 1,000 Rand maintenance, you are stuck with a 1,000 maintenance until for the next few years, until the kids are on their own. So it's important to make those proper informed decisions.
I'm just thinking, Advocate, that someone may be listening at the moment and thinking that, you know what, I may not have done the correct thing when I went through my divorce proceedings. Is there any way that you can go back if you've divorced maybe like a few years ago?
No, there's nothing you can really do. The only thing that you can deal with is the kids' issues.
Okay.
Those doors can always be opened. So if you agreed upon a low amount of maintenance and it's clear now that you require more maintenance, at any time, a month after the divorce, you can come back to the maintenance court. Regarding care and contact as well, let's say you guys came to an agreement, you say the kids can go to the dad, but now the kids 2 months later say, no, we don't want to be with dad because dad remarried and we don't like the new wife and she's getting very nasty with us and I cannot study. You can approach a court regarding that again. But when it comes to the property aspects and the money aspects, there's not much you can do there.
Wow. Well, Advocate, it's certainly been very interesting speaking to you. So shukran so much for your time as always. Advocate Mohammed Abduroaf is an advocate of the High Court of South Africa, also a family law expert, and he helped us better understand the legal and financial realities of divorce.